A good day to you all. My name is Mufaro Tewende, a second year law student at African University. Um, Today we are going to discuss on the law of delict, particularly focusing on breach of statutory duty, negligent performance of statutory duty, strict liability under statute, and vicarious liability. First of all, we are going to discuss what is breach of statutory duty and the components, as well as the defenses that are raised under breach of statutory duty in the law of delict. So statutory duty is a legal obligation that requires companies, organizations, professionals, and governmental bodies to act in a certain way. It is a legal obligation that is imposed on governmental authoritative sects and local governments to act upon certain issue rather than not to. For example, let's say it is the duty of a rural district council in Zimbabwe to appoint local government officials by following the recommended procedures of electing one to that post. So in other words, we are just saying it is a regulatory law imposed on an organization that is governmental, a business or a company, as well as professionals of a certain job, which must be legally adhered to as according to the fundamental principles of such law. So there are instances where the subjects of the government do not comply with these legal obligations outlined to them by the Constitution, or they fail to honor the provisions by not doing or omitting to the legal action required to them. So that is what is known as a breach of statutory duty. So the breach of statutory duty in most cases comes in forms of where the governmental or constitutional subjects, rather to say, overlap the standard of operation that are prescribed by the law. So as I was saying, a breach in most cases comes in forms of where the governmental or constitutional subjects, rather to say, overlap the standard of operation they are prescribed by the law, or they fail to follow all the procedures required of them to fulfill a statutory act, or they fail to comply with the statutory duty assigned to them by the law as a whole. So when a breach of statutory duty is enacted, damage is usually incurred in such an act. And in most cases, these damages are civil and they are delictual in nature, to be precise. So now we need to understand how the courts deal with breach of statutory duty. So to begin with, a person who suffers damages or harm from a culpable statutory breach has a right to claim delict for damages caused. The plaintiff must establish all necessary components of a delict, including wrongfulness, which I have mentioned. So it implies that the plaintiff must prove with the balance of probability highly in his favor, since it's a civil case, that a statutory duty in question of breach was a direct interest to him, whether as an individual or as an organization experiencing harm or damage as a result of that breach. Another issue which is taken into account when dealing with these statutory breaches the the mischief which is intended to be prevented by the statutory duty imposed by the respective authorities, that is the legislation. In this situation, the courts mostly examine and analyze the content of and purpose of a statute in question of breach. So the interpretation of the statute's intention is taken into account as well by evaluating whether a possibility of delictual liability is created when the duty is breached. It is important to understand that if the statute did intend to prevent this, then the defendant owes the plaintiff a delictual duty, and the notion is that provided the other conditions for culpability are satisfied or for delictual liability are satisfied, then harming someone by breaking such a duty may be considered wrong, and thus it can be involved in a delictual liability. So when interpreting these statutes that are in question of the breach of statutory duty, the courts also look at the object sought to be achieved by the provision, which in other words are the intentions of the statutes. Uh, this will be this will in most cases include the duties and procedures that are involved, as well as the natures of the powers conferred by the statutory duty, with the respectable remedies that are available to such a breach. So these remedies are made available to the plaintiffs who have suffered harm or who have suffered harm or damages are also considered by the courts when examining a statutory duty. So aligning with these examinations in line with the components of the statute itself, as well as administrative law. So when dealing with breach of statutory duty, the main focal point of civil courts is the content and purpose of the statutory duty in question, along with its associated consequences caused by the breach, more than the rights of the plaintiff. So the court's focus is more on the statutory design more than the rights of the plaintiff, which he claims to have been violated. This is because delicts are handled on the balance of probabilities, since in most cases they are civil cases and the standard of proof is based on balance of probabilities, and which subsequently mean that the defendant breach of statutory duty is not cast in stone wrongful in respect to delictual liability. So in this presentation, I took account to a South African case, that is the case of Hang and Paragliding Association in Bewick, which is a Supreme Court case, and I examined the ruling by the Court of Appeal of South Africa, which read that even on the assumption that the appellants had failed to perform a duty imposed upon them by the statute, the question remains whether their omissions were wrongful in the delictual sense. To the uninitiated, it may sound contradictory to say that the omissions to comply with the statutory obligations are not wrongful, but that impression loses sight of this special meaning attributed to the elements of wrongfulness in the context of delictual liability. As I have said by the way of introduction, wrongfulness in this context means that in accordance with judicial determination, consideration of public and legal policy dictate that it is reasonable to impose delictual liability on the defendant for the harm caused by the omission involved. So with the above verdict in mind, one might conclude that a breach of statutory obligation does not conclusively constitute to wrongfulness and negligence. So there is the reasonability of the defendant's conduct, which is also looked upon, as well as the probability of foreseeability, which is an essential element when looking at negligence, is also put on a judicial scale to achieve the wrongfulness of the defendant's breach of um of of breach of statutory duty. So like in many cases, as we know, there are defenses that can be raised when one is being in trial for breach of statutory duty. So a defendant can raise contributory negligence as a defense to avert from being liable to breach of statutory obligations, as well as voluntary assumption of risk. So in contributory negligence, the ministry in a way is given statutory discrimination, discretionary powers, not discrimination, in which they are immune to 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 a delictual act. And if the negligence that is within the breach of statutory is contributory in nature. However, on the side of voluntary assumption of risk as a defense, it is doubtful to raise it against claims of breach of statutory duty. Moving on, we are now going to discuss on negligent performance of statutory duty, what it is, and elements of the negligent, as well as remedies. So there's the difference between negligent of performance of statutory duty and breach of statutory duty lies within the conduct. In a way, the negligent part says it all, because in statutory breach, the subject in this matter is violated all the the statutory obligations, whereas in negligent performance they might have adhered to the statutory obligations, but in a way they are acting in a negligent way. They are aware, but now they are acting in a negligent way. So there's the issue of recklessness. So that is what is under the the negligent performance of statutory duty. So here it is another delictual wrong that individuals may claim damages for. Negligence is characterized by failure to take reasonable care in the performance of one's duties. So under the elements of negligence, the plaintiff must prove the existence of duty of care, a breach of that duty, as well as that harm was caused as a result of the negligence of the state's subject, and that the harm was foreseeable as a result of the negligence. Like I said earlier on, negligence is foreseeability is an essential element. So you need to prove that there was a foreseeability that due to this conduct by the state subject, there was going to be harm as a result of that negligence. Then moving on to the remedies, the the civil courts, like in most delict cases, the most used remedy is compensation. You just repay or repair or pay a certain, it's not always in monetary value, but there is the need to pay for damages, or to repay, to compensate for damages suffered as a result of this negligence. Then moving on, we go on to strict liability. So first of all, we need to understand what is strict liability. Strict liability, it is a liability that does not require proof of fault for one to be regarded as liable to a certain conduct. So a person tried under strict liability, if you have noticed, is held liable for damages or harm with little or no regard to whether they were negligent or not in their conduct. So strict liability sort of removes the freedom to prove fault from the defendant in a civil case in most cases, though it is also available in criminal cases and other bodies of law. In delict, um, it is also found in, I'm just going to give examples. There's the acto de pauperi, which is harm caused by animals. There's the acto de pasto, which is under animals, which is harm caused by grazing animals, as well as the positive vel suspensi, which is a Latin maxim that stands for harm which is caused by objects that are falling down from a building. These are some of the examples where strict liability is applicable in under delict. So in this case, we are just going to look at some of the cases or scenarios where the Zimbabwean law has adapted to strict liability under delict. If you look at the Civil Aviation Act, that is section 70.2 of the Act, chapter 13.11, it provides for the recovery of damages of the owner of an aircraft without proof of negligence where material loss is or damages to any person or property on land or water is caused either by an aircraft while in flight, whether taking off or landing, or by a person in, or an article or a person falling from an aircraft while in flight, taking off or landing. So it doesn't matter whether it's the aircraft itself or things that are within the aircraft. We are talking about either objects, let's say part of an engine or the cargo or the pilot himself. They are just held liable under strict liability, and they are required to pay for the damages, to compensate or to give any other relevant remedies under the the act. Moving on, there's also the Road Traffic Act. So this act, it also gives a strict liability in instances where, while driving a public passenger vehicle, while driving a public passenger vehicles, there is harm caused, let's say due to accidents, and according to the act, there are certain amounts, though this one is a remedy of compensation, but in monetary value. In most cases, there are certain amounts that are paid in the event of death, in the event of injuries, and so forth. So that is what strict liabilities has been adapted in the Zimbabwean law courts and in the Zimbabwean law per se, through the Civil Aviation Act and the Road Traffic Act, among other acts. This is just an example showing strict liability under vicarious liability. Then moving on, when under strict liability, moving on, we are going to focus on vicarious liability. What is vicarious liability? It is also known as the employer's strict liability. In this case, it now focuses on the employer who, let's say, an owner of a job but is hired someone to work under them. So it holds the employer liable without fault for the wrongdoings of his employer, provided that these employees are not independent contractors. So this implies that in the event that there is an independent contractor, an employer is not held vicariously liable to the actions of that independent. By the way, independent, it means that there is no attachments whatsoever to the actions of the employer and an independent contractor. These are some of the differences which you need to look when you are looking at vicarious liability, particularly in Zimbabwe, focusing on the employer-employee relations. So there is no room for the employer to prove that to raise an argument that he was not aware of his employee's actions, and the employer is bound solidum. Solidum is a maxim that means together with the employee due to the scope of their employment. For instance, let's say a driver from my university, which is Africa University, driving a university's car on duty of transportation, let's say of something, let's say stationary, runs over a cow. The cow's owner, instead of suing the driver, sues the employer, which in this case is the university, and the university is bound to pay all the necessary damages or to compensate for the damages incurred to the farmer, as it is solidum again liable to the delictual act committed by their employee. There are various reasons that are taken into place or that are considered by the courts to hold the employee vicariously liable to the actions of their employees, which I'm going to explain later. So in most cases, let's say for first and foremost, there's the employee financial incapacity. So the employee is financially or resourcefully incapacitated to cater for the compensation needed in most cases. So this is why the court have left room for employees to be liable to their own delict. That is, in the event that they are financially and resourcefully capacitated to pay for these damages. Rather, the employer in most cases, apart from the employee, is financially capable for paying for the respective compensation demanded by the courts, and this he can also do on behalf of the employee. There's a justification as well behind this idea that employers can pay for the damages caused by the employee, in the sense that the employee causes harm or damages to the complainant or the plaintiff while pursuing his employer's commercial or whatever sort of commercial or, yeah, in most cases commercial interest. So since the employer yields benefits from the employment endeavors, the employer should also be able to bear losses arising from his employee's accidents, the same way he would have incurred losses if the same employer was not in an accident, but for example made a mistake while performing a certain task. So in this case, we are looking at a scenario where the most beneficiary out of the actions of the employee is the employer. So they must take into consideration the fact that if there was no accident, the employer was going to benefit from the employee's actions. But in this case now, there's an accident. So an accident is viewed as the same way as a mistake is viewed by the courts, in the event that when a mistake happens or occurs within a business, some mistakes leads to losses, and the losses, they are incurred by the employee but mostly by the employer. So they must be viewed on the same level, that the employer must also incur the losses that are caused by the employee's conduct, is the same way that they view their losses even in a delictual act or in a conduct that has led to damages to be caused to another person who is not an employee, who is just let's say a complainant in this event. So another thing to look is the risk absorbers. Employers are viewed as risk absorbers because they can be or are able to manage losses or accidents effectively. They are assumed to be able to distribute the costs arising from paying damages, either through insurances or any other sources of financial income. And they are also able to take mitigating to take mitigating measures by allocating resources. Since they are employers, in most cases they have more resources than their employees, like I mentioned earlier on. So they are able to allocate resources in finances that are associated with their type of business enterprises. So the risk discussed here is derived from the view that by assigning their employers in a way will be sort of shifting responsibilities along with its associated risk to their subject, which in this case is their employee. Therefore, when any damages are caused by the employee, it is on the employer to pay for the damages caused, is they are whether knowingly or unknowingly part of the risk that is delegated to the employee. I hope this is more understandable. Then there are sort of factors that are considered to understand the relationship between the employer and the employee when dealing with these cases of vicarious liability under employment. So there is the issue of there is the issue of the employment relationship which exists between these two parties, and it is also known as the locatio conductio operarum, which is a maxim term that is known for employment relationship, and the conduct of services. So they look at the scope of of employment. Was the employer during the time of the accident or the delictual conduct that led to damages, was he operating within the scope of employment, let's say the perimeters, the distance, the time, and within the instructions of the employer. Also, there is the issue of the nature of the work, the working hours, paid time. How is he paid? Is he paid in a way that he is capable of, yes, of compensating if there is a room that he is liable to the to the to the delictual act. So these are some of the considerations that are taken when dealing with strict liability. So there are also other situations that arise from vicarious liability, such as the deviation from course of employment. The fact that an employee deviates from the course of employment will not disregard the employer from being vicariously liable to a delict committed by his subjects. This is whereby, let's say, that driver I have mentioned earlier on sort of uh let me let me find the right word, sort of temporarily leaves the assignment to pursue a certain interest, let's say to see and to go and see let's say his girlfriend with the company car. And during that deviation, an accident occurs that causes damages, that causes harm, that causes, let's say, death or something to a certain individual. So the extent to which the employee has deviated from the course of his employment assignment is considered by the courts mostly based on social justice. If an employee temporarily leaves the company's business while it is in progress to pursue personal interests, the courts will determine whether the deviation was significant enough in terms of time and distance. Like I said, the courts will consider the distance of deviation. Was it within the area of the scope of the perimeter of the employment, and how much time did the employee deviated from the course of the employment. So the court will determine that, and to make it impossible to reasonably infer that the employee was still performing the duties for which he or she was hired for. Yes, and there are also other cases where situations where instead of deviation, now the 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 employee now abandons the workplace while he was supposed to be on duty, according to the time frame of his work designed by his employer. So in this case, it does not as well exclude the 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 employer from vicarious liability if there is a foreseeability that he knew that his employee might do something like that. Let's say there is this case of Widam versus Minister of Home Affairs. It is a Zimbabwean case. A police deserted his guarding post. He had past alcohol abuse cases and psychiatric issues. So he deserted his guarding post while guarding uh, the minister's premises during the night watch, and he went on a shooting spree in an area not far from the minister's place of residence. So he shot at a couple, severely injuring the husband and killing his wife. So his abandonment was a clear exclusion of himself from his employer's risk absorbance, like the risk absorbent we have talked earlier on, in favor of his own. However, the ministry was directly liable as it created a danger by placing an officer on duty even with the full knowledge of his psychiatric history with a loaded firearm, which amounted to a foreseeable risk of public harm. So the police also owed the public a duty to care, to protect them from a gunman in general who is off the leash, but more specifically against a fellow member of the police who was in uniform on a duty using a state weapon to attack. So like I said, they consider as well the issue of negligence, foreseeability, when and the distance and time rule, which says if the operation was within the time of employment, within the scope and the perimeters of employment as well, then there is the employer is held vicariously liable. There's also a situation where employees disobey their employers instructions. There's a crucial analysis that is used to determine vicarious liability, which is derived from a question of balances, whether the instructions limited and define the actual sphere or scope of employment, or whether they merely sought to regulate the conduct of the employee. within his sphere of employment. If it is the former, then disobedience to instructions will mean that there's no vicarious liability. While on the other hand, if it is the latter, which is the regulation of the conduct of the employee, then the employer will be vicariously liable. So this is my presentation on uh, breach of statutory duty, vicarious liability, and negligent performance of statutory duty, as well as strict liability. I hope you guys understand and get a scope of what is um, these statutory, like I mentioned earlier on, these topics, and you understand and might use it to supplement some of the knowledge that you may get earlier on. Thank you very much.